Can I afford to file a lawsuit? Hi, this is Consumer Protection Attorney Bill Clanton. Clients often ask me, can I afford to file a lawsuit? Here's the thing about consumer law claims. They typically, most all of these laws, have fee shifting provisions, meaning that at the end of the case, the attorney who represents you will be able to apply to the court or collect from the bad actor their attorney's fees. That means, for example, under the FDCPA. The FDCPA says that if you sue a debt collector, then the debt collector is liable for your actual damages plus statutory damages of up to $1,000 plus your attorney's fees and costs. So at the end of the case, you will get your actual damages under the law. You'll get your actual damages, your statutory damages, and your attorney will get their attorney's fees and costs. Costs in a case like that are $400 for a filing fee, deposition costs, and other costs, hard money that is spent in bringing your claim against the debt collector. The Fair Credit Reporting Act has the same language. The Deceptive Trade Practices Act, a Texas law, says the same thing, that your attorney can recover their attorney's fees under the law. There's a couple of exceptions to this, and one of those is the Telephone Consumer Protection Act. The Telephone Consumer Protection Act does not provide for attorney's fees, but damages under the Telephone Consumer Protection Act can be very high. And so attorneys typically take a 40% interest in these cases, and so they get paid at the end of the case. Auto fraud is another area where people wonder if they can afford an attorney. Well, typically, under consumer protection laws like the DTPA and breach of contract theories, under Texas law, if you give notice to a party that they've breached a contract, then you sue them, then you can recover your attorney's fees. There has to be that notice first to be able to recover the fees, but your attorney should be able to recover their attorney's fees for breach of contract and should not charge you. So, surprisingly, you should be able to afford an attorney because an attorney should not charge you any money to get started on a consumer law type claim. Like I said, the FDCPA, the Fair Credit Reporting Act, the Truth in Lending Act, all have provisions, and the Deceptive Trade Practices Act. And this is just the tip of the iceberg. Lots of consumer protection statutes include provisions for attorney's fees. So an attorney should not charge you to get started on your case. You should be able to afford an attorney to help you out. That's why these laws were made, and that's why they are fee-shifting laws, so that debt collectors, credit reporting agencies, car dealers, mortgage servicers, and other bad actors can't get away with their bad behavior just because somebody wouldn't normally be able to afford a lawyer. So it keeps them straight, keeps them honest, and gives you the right to pursue them without having to take anything out of your pocket. If you're in one of these situations, give us a call. We'd love to talk to you, see how we can help you out. Thanks for watching.